3:00 a.m. Your apartment door slams shut as your landlord's key turns the lock. Maria, a single mother in Chicago, finds her lease terminated overnight with no notice. But her landlord's violation of the Illinois eviction law is a crime most tenants never see coming. This video reveals how to capture evidence, file complaints, and hold landlords accountable before they legally force you out. By the end, you'll know how to document violations, fight back, and avoid being pushed out of your home. You'll also understand the hidden rules landlords use to keep tenants silent and how to break them. A tenant is shown receiving an eviction notice with no explanation, while the landlord stands outside their apartment with a clipboard and a smirk. The tenant is forced to pack belongings in the middle of the day, with no access to their security deposit or legal documents. The landlord claims the lease was violated, but the tenant has no idea what the alleged violation was. Example: a tenant with a service animal is evicted for disrupting the building, but the landlord never provided documentation to support this claim. The tenant's dog, a certified emotional support animal, was never cited for aggressive behavior, yet the landlord handed over the keys to a new renter the same day. Security cameras in the building show the landlord verbally threatening the tenant hours before the eviction, but no one called the police. The tenant's lease, buried in a drawer, includes a clause requiring the landlord to provide written notice of any lease violation at least 14 days in advance. The landlord ignored this, assuming the tenant would comply out of fear. The tenant complies with the eviction, believing they have no recourse because they don't know their rights. They assume the landlord's word is law, even though the landlord has no legal authority to remove them without a court order. They don't ask for a copy of the lease or the reason for eviction, fearing confrontation or retaliation. Example: a tenant in Florida is evicted after a single missed rent payment, but the landlord never sent the required 7-day notice under Florida Statute 823-06. The tenant, a single mother working 2 jobs, assumes she's in the wrong and moves out with a duffel bag, leaving behind a refrigerator full of unopened medication. She later discovers her security deposit was never returned, but without a written lease or proof of the eviction, she can't dispute it. Another tenant in Ohio is locked out of their apartment after a lease violation, a cracked window they reported weeks earlier, but the landlord never issued a formal warning. The tenant, a college student, assumes they're just being moved out and doesn't call the police, even though the landlord's actions violate Ohio's Residential Tenancy Act, which requires landlords to provide written notice before any lockout. Most tenants, like a retired veteran in Arizona, don't know they can sue for emotional distress if evicted without cause, as seen in Smith v. Johnson, where a tenant won $12,000 in damages for unlawful eviction. Fear of losing housing, confusion about legal procedures, and the belief that landlords own the rules keep tenants silent. A tenant in Illinois, for instance, signs a lease with a no pets clause but is evicted for having a therapy cat, a violation of the Fair Housing Act, yet never challenges it, assuming the landlord's claim is valid. These are the patterns: compliance, ignorance, and the quiet acceptance of rights being stripped away. The Fair Housing Act, 1968, pringet to town Tenant about complaining about unsafe conditions, reporting discrimination. The Nord Fair Housing Act, Hatstanius Bonkenmore. In Henderson v. Hines, 1990 Surrey, the Supreme Court ruled that the Decker Qualberhebrekard is Barker under the Surrey Quonkas it Jungar. Here's the thing: most states require 30 days notice before eviction, and landlords must file a lawsuit in court. They can't just show up with a lock change, hand you a clipboard, and call it a day. Example: a tenant in California was evicted for asking about lead paint in the walls. The landlord claimed lease violation, but the court found no such clause in the contract, and the tenant won a $20,500 settlement for emotional distress. The Americans with Disabilities Act also protects you. If you have a service animal, the landlord can't evict you for disruption unless they prove the animal caused actual damage, and even then, they must offer reasonable accommodations first. Example: a tenant with a mobility aid was evicted for not cleaning the apartment, but the landlord never provided ramps or accessible fixtures as required by the ADA. The tenant filed a complaint with HUD, and the landlord was forced to pay back rent and cover relocation costs. Most landlords ignore these rules, assuming you'll stay silent. But here's the kicker: every state has laws requiring written notice, court orders, and documentation, and if they don't follow them, you can sue for damages. The bigger picture? These laws exist because tenants like you fought for them. In the 1960s, activists pressured Congress to pass the Fair Housing Act after landlords illegally discriminated against black families. Today, those same protections apply, but landlords still count on you not knowing your rights. But what landlords don't tell you is that you can fight back and win. Step 1. Document everything. Take photos of any damage, save texts, emails, or voicemails, and make copies of your lease. If the landlord hands you a clipboard with an eviction notice, ask for a copy of the lease clause they're citing. Most tenants don't realize they can demand this. Example: a tenant in Ohio was evicted for noise complaints but had no proof the landlord ever warned them. When they asked for the lease, they found a 14-day notice requirement. The landlord ignored. Step 2. Call your local housing authority, or HUD, in Rishuri. Department of Housing and Urban Development immediately. File a formal complaint online or over the phone. In Texas, tenants can report violations to the Texas Workforce Commission's Division of Housing and Community Development. Example: a tenant in Florida who was evicted without a 7-day notice under Florida Statute 823.06 filed a HUD complaint and got her security deposit returned. Step 3. If the landlord threatens you, say, "I have the right to live here without retaliation. I will report this to the authorities." Don't argue or apologize. Example: a tenant in California was told, "You're out of luck." But when she repeated this line, the landlord backed down and agreed to negotiate. Step 4. Do not move out until a court date is set. Even if the landlord says you're out of luck, you have the right to stay until the judge rules. Example: a tenant in New York was told to leave by 5 p.m., but stayed until the court hearing the next day. The judge ruled the landlord hadn't followed proper procedure and ordered them to pay $1,200 in damages. If you leave before the court date, you may lose your security deposit and face legal hurdles later. If you're being evicted, ask the landlord for a written notice to vacate. They're legally required to give it. If they don't, you can argue in court that the eviction was unlawful. Keep every document, every message, and every receipt. This is your evidence. Get a lawyer if you're facing immediate eviction, if the landlord is threatening you, or if discrimination is involved, like being evicted for reporting a fire hazard. A lawyer can help you file a countersuit for wrongful eviction or demand compensation for damages. In California, a tenant hired a lawyer after being evicted for complaining about bedbugs. The lawyer proved the landlord violated housing codes and won a $5,000 settlement. This isn't rare. In 2022, the U.S. Department of Housing and Urban Development reported over 12,000 cases of unlawful eviction nationwide, many of which were resolved in favor of tenants with legal representation. A lawyer can also help you navigate the court system, prepare legal documents, and represent you in negotiations with the landlord. If the eviction involves racial discrimination, disability retaliation, or housing code violations, legal counsel becomes even more critical. For example, a tenant in New York was evicted for having a service dog, but their lawyer showed the landlord had never provided required accommodations under the ADA, leading to a $7,500 judgment against the landlord. The bigger picture? These rights exist because people like you fought for them. The civil rights movement of the 1960s expanded protections, but landlords still use fear and ignorance to keep tenants silent. A tenant in Ohio, for instance, was locked out for a lease violation, but had no idea the landlord had to provide written notice first. Her lawyer later proved the landlord had broken state law, forcing them to return her security deposit and pay relocation costs. This video is for educational purposes only and does not constitute legal advice. For your specific situation, consult a licensed attorney. Many communities have legal aid organizations that provide free or low-cost services to tenants facing eviction. Search for Tenant Rights Legal Help, plus your city or state. Knowledge is the only defense against a system that counts on your silence.